You're up. Very good. Just a few announcements as we get going. Please turn off your cell phones or turn them to mute. If you need to make a call, please leave the room. If you intend to propose a substantive or lengthy amendment to a bill, we will need written copies for each member of the committee and 2 for our staff. If you need to have copies made, you can go across the hall to the copy center and Miss Sandy Gent will assist you. The meeting is being streamed live on the legislature's website. A link is located on the meeting calendar page. Those who are not wishing to testify online are encouraged to watch the proceedings on the legislature's YouTube channel. We will typically proceed through our bills with the sponsor, and if the sponsor has a primary witness, those folks will testify first. Then we'll take testimony from other legislators in the room, then state agency or court officials if they're in the room, then representatives of interested organizations, followed by general public comments, both virtual and live here in the meeting room. We ask those who are going to testify to come up to the table, press the button until the little green light comes on your microphone. Say your name, and if you're new to this committee, please spell your name for our record. When you speak, please speak clearly and with some volume so that the committee can hear you, others in the room can hear you, and perhaps most importantly, those who are watching our broadcast will be able to hear you. If you're here as a representative of an agency or an organization, please state which organization you're representing. If you're here as a private citizen representing yourself, please tell us where in our great state you reside. Remember that all dialogue must be first addressed to the chair rather than a direct conversation with any member of the committee. Witnesses are expected to remain polite and civil during their testimony. Audience members online wishing to testify should register now using the testify button to provide our staff with notice that you're interested in testifying in a virtual format. They will give you instructions as your time to speak approaches. Raise your virtual hand if you're online, and then the staff will be able to modify your credentials so that you'll be able to testify. Today, we seem to have more interest in our bills than we've had previously. So I ask everyone to speak concisely, probably about 3 minutes, unless the chair authorizes you to speak longer. Once virtual attendees have concluded their testimony and or if you're watching and do not anticipate providing testimony, please move to the YouTube channel and watch there because we can only have a limited number of people queued up to testify virtually. So the first bill on our agenda is House Bill 128. Representative Costin, I'll come forward. Well, welcome to House Judiciary. Pleased to have you with us today. And why don't you just kind of walk us through House Bill 128?
Thank you, Mr. Chairman and representatives. This bill was brought to us by a county attorney from the western part of Wyoming. It's a technical fix that they've encountered. I also ran this bill by the county attorney for my county. He was also in favor of this bill. The way the law is currently written, it says secretive nature into, but we're going to add or within. The technicality came up with somebody inside a dressing room filming somebody. So this would help take care of that technicality. I've also provided you with just the US Code of Voyeurism. I don't know, with not being an attorney, but I didn't know if there was any language in here that maybe as you guys work this a little bit, there may be some things you want to add to that. It just goes through and details, I think, a little bit better in the US Code than what our current code has, but I'm going to leave that up to you experts.
All right. Representative, could you give us a little more of an example of how someone would be a voyeur in the same room with someone and not be detected?
Yeah, hiding in an area where there's multiple dressing areas, right? Like hiding in a bathroom stall with a video camera and there's someone in the dressing room undressing and they're videoing that person. So they're in the same room as that person, dressing room, but that person is unaware. The way the current law is written, they would have to be outside the room videotaping them. So this helps clear up that technicality that they ran into.
Anything further?
No, I hope it's a simple fix that we can take away a technicality that criminals can't get away with. Way to help protect our citizens.
All right, committee, any questions for Representative Clausen? Seeing none, do you have any other witnesses with you this morning?
I met.
All right, anyone else in the room wishing to testify on House Bill 128? Anybody virtually for 128? All right, committee, what's your preference? Moved by Representative Crago, second by Representative Oakley. Okay, any committee, any recommendations for amendment on the bill? Representative Chesney.
I just have a question. Maybe, and I haven't done the study, the research on this because I don't have any real problems with this bill. I'm just wondering if there's another section that covers surreptitious videotaping. Somebody might have a remote camera set up. Is there another section that covers that, or is that something we ought to add here?
Representative Clausen, do you know?
I don't. Again, this was just a fix from a couple of the county attorneys to help them prosecute some cases.
Others, Representative Crago? Other comments on the bill or proposed amendments? All right, we'll wait for a minute while Representative Crago checks on the recording language. I remember we dealt with that recently. Representative Crago.
Thank you, Mr. Chairman. I think if the good representative, if you go pull up the rest of that statute, it'll answer your question. If you just, there's a whole laundry list of stuff under 64304 to which we're only looking at the very beginning of the statute, and the rest of it kind of goes through goes through the very question you had.
Further comments, questions on the bill? Are we ready for a question? Question being called. We'll call the roll on House Bill 128.
Representative Crago,
Aye.
Representative Chestick. Aye. Representative Haroldson, Representative Jennings, Representative Nemec,
Aye.
Representative Oakley. Aye. Representative Provenza,
Aye.
Representative Rodriguez Williams.
Aye.
And Chairman Washut.
Aye.
That is a total of 9 ayes and 0 noes.
Representative Clausen, I assume you're going to carry the bill on the floor? Very good. Thank you much. It takes us to House Bill 126. Representative Crago, we have House Bill 126. Would you walk us through the bill, please?
Thank you, Mr. Chairman. Committee members, I bring to you House Bill 126. Ask for your favorable consideration this morning. House Bill 126 is entitled Removal of Trespasser. It's actually a constituent bill, and I have my constituent with me. So these are the best kind of bills where people bring us ideas and we try to implement those ideas. And really what this bill is doing is mirroring the language from a lot of other states around the country regarding the ability of people, especially in Mr. Gray here in a second, will probably get into a better explanation of why the language is needed. But it really has to do in today's day and age, we get into situations where we have people in businesses, churches, et cetera, where we're worried about them causing imminent harm to somebody. And a good way to de-escalate that situation is to get them out of the building. And that's really what this language is about, is de-escalating situations before they get to the point where we have to do something serious. And so that's really the gist of the bill. And I'll be ready to answer additional questions, but if it's okay with the chairman, I'd like to turn over the discussion to Mr. Gray.
Mr. Gray, is it? Would you state your name and spell it for the record and then tell us what we need to know about House Bill 126? Welcome to House Judiciary.
Thank you, sir. Good morning, Mr. Chairman, committee members. It's an honor to be here. My name is Tim Gray. I'm from Buffalo, Wyoming. Obviously, my reason for being here this morning is to address the proposed amendments to Wyoming Statute 6-303 criminal trespass. New language would allow an owner, legal occupant, or their agent to use reasonable physical force to terminate the trespass. My idea actually came from adoption from the trespass law from Colorado Revised Statute 18-1705. I had more information on that, but Representative Craig has found many other states that also have a similar law. The one in Colorado has been tested in court, specifically People versus Hayward, as well as People versus Toller. And it still stands today. And I would think if it had become troublesome in Colorado society, it likely would have been removed by their legislature. Here in Wyoming, a Wyoming resident is greatly protected within their home in the defense of self or another. This is evident in the self-defense statute 6-2602 and is obviously well documented in Wyoming case law, where a Wyoming owner or occupant or agent is not well protected as a church, business, or a school. I see this amendment as a de-escalation tool specifically in our schools, churches, and business. Quick example, consider a teacher or principal who's attempting to de-escalate a verbally abusive subject in a school. The principal has had police notified and has asked the person to leave, even advised the person that they are trespassing at this point. The person's continued to be disruptive, disturbing the ongoing business of the school, and still refusing to leave. The principal asks a teacher to assist in the removal of the person from the school building, then locks them out. I think anyone in our society would see this as a reasonable, appropriate action in this case. I know objectively as a parent, I would see that as a reasonable action of protection of children. The principal and the teacher should not fear criminal repercussions for this act. The same scenario can also apply to a church security team, business owner, or a bouncer. Currently under Wyoming Statute 62501, simple assault and battery, the principal, teacher, church security team member, business owner, or a bouncer is involved could face a charge of battery or unlawful touching for doing what reasonably would be expected in these types of situations. I mentioned earlier, I see this as a de-escalation tool. When you're dealing with a verbally disruptive person, you can read their body language, facial expressions, and tone changes can usually determine when the situation is deteriorating. What you can't do is read their mind. You know, are they preparing to commit physical act of violence, or worse, pull a gun and escalate to inflict death or serious bodily injury on innocents? By removing the disruptive person before this happens, we can de-escalate the situation, create it from escalating, and potentially save lives. Now, I do firmly believe that law enforcement should always be called, should always be involved, but they must be there to be involved. National response times around our country are approximately 5 minutes on a 911 call. And that's if they have a city police force. When response times can vary on factors such as number of calls for service, location of nearest available officer, traffic and road conditions, just to name a few. However, in our rural areas, churches, schools, businesses may be looking at a much longer response time. I'm sure there are many of you in your areas where law enforcement response time, it could be 35 minutes or more, just because of distance that they have to travel. Again, removing a disruptive trespasser using reasonable physical force before they become violent just makes reasonable sense. It's a reasonable alternative, potentially physical and or deadly attacks. Real quick, the addition section D just clearly limits the use of physical force only to remove the trespasser. And section E makes it clear that this does not supersede or add to defense of self or others as provided by law. And I realize that there may be some verbiage changes to this bill. to make everybody happy. I get that. My biggest concern as a constituent would be that the verbiage not change or, not add to or supersede Wyoming statute, case law, and jurisprudence already established in defense of self or others. I've discussed my concerns with the county attorney, prosecutors, representatives, and others. All agree the verbiage must not add to or supersede Wyoming self-defense jurisprudence. All agree the intent is worthy. It's just about getting the verbiage correct, so that we protect our Wyoming citizens from unreasonable prosecution. Obviously, we don't want to create vigilante justice, and we don't want to interfere with Wyoming self-defense jurisprudence. Thank you for your time. I'm sure you probably have questions for me. I'll do my best to answer them.
Committee, any questions, Mr. Gray? Representative Rodriguez Williams?
Thank you, Mr. Chairman. Probably a question for Representative Prego. I'm just curious, under the statute, under A1, when it talks about notice being given to notify somebody that they shouldn't trespass. I'm just curious if one or the other carries more weight when it comes to notification, whether it's notification by an individual or notification by law enforcement, and how that would play out with this amendment.
Representative Craigle?
Thank you, Mr. Chairman. Representative Rodriguez Williams. I don't think it matters who the notice comes from. I mean, the statute specifically says personal communication to the person by the owner or occupant or his agent or by a peace officer. I don't think it matters who the notice comes from. Notice is notice. If you're put on notice, you are a trespasser. You're on notice. And so I don't think there is any difference in who that notification comes from as far as precedence or order of importance.
Further questions? Representative Harrelson?
Thank you, Mr. Chairman. Mr. Gray. So first of all, thank you for being here. Thank you for coming before us and having this conversation, for making the drive from Buffalo. If you wouldn't mind, could you give us what prompted this? I doubt it was like couldn't sleep at night and was looking through other states' laws. I mean, obviously there was something that happened that prompted this conversation. Could you obviously with your wisdom on maybe details, but could you just kind of give us an idea of where this was an issue and how this could have helped fix the situation?
Mr. Chairman, Representative
Mr. Gray.
Harrelson. I own a business, Firearm Safety Training LLC. One of the things that I do is I train church security or safety teams, helping them in different aspects of that. One of the main questions I always get is, when may it be lawful to touch someone? And an obvious answer is in defense of self or others. But what about a disruptive subject? I'm like, well, you're looking at basically the doctrine of necessity, the lesser of two evils, because if you touch somebody, yeah, you could be charged with a crime. At some point you have to determine, is touching this person a better thing to do to stop this situation or not? And realize that, yes, you may face charges. Just like if you're in a defense of self or others, you may do everything right and still face charges. So does that answer your question, sir?
Representative Harrelson, follow up?
Thank you, Mr. Chairman. It does. Thank you very much.
Representative Oakley?
Thank you, Mr. Chair. So this question is for Mr. Craigo. Can you tell me what you think that this law does that doesn't already exist, if there is, or just discuss this? What you think the law does that already doesn't exist, not maybe in statutory form, but common law, that this solves? Do you think this solves the problem?
Representative Craigle?
Mr. Chairman, Representative Oakley. I do believe this law already exists in common law. I think we have this right as Wyoming citizens. The problem is, and this is the problem that it solves, is that most people don't know where to look that up. They can go to a lawyer and say, hey, where is this right granted to me? I think that's the problem we're trying to solve today, is so that people like Mr. Gray can, when he gets the question, can say, well, it's in 63303. That's where it says you can do that. And rather than us referring them to a long list of cases or common law doctrine, we're just trying to make it clear for the general public that this is allowable in Wyoming under the circumstances set forth in the statute. proposed statute.
Thank you. Further, Representative Provenza?
Thank you, Mr. Chairman. Thank you, Mr. Gray, for being here today. My question is, I think maybe oftentimes, I don't know how often, to be fair, but people who refuse to leave property, who are trespassing, may be struggling with substance abuse, mental health issues. And so interacting with them doesn't produce the same results as if you were to be dealing with someone who's not in that state of mind. And so that is typically going to end up potentially being an escalation if you interact with them in a physical way. And so law enforcement has training they have de-escalation training, they'll have crisis intervention teams training. In the laws that you looked at in other states where it's held up, I mean, what have been the issues? When has this gone wrong? If you know of anything.
Mr. Gray?
Chairman. Representative Provenza, I don't know of any instances where it's gone wrong. I fully understand what you're saying about police officers have much more training in verbal de-escalation, using empty hand techniques. That is for sure. The person that you described, somebody that's suffering from mental illness, or they're high on meth or something like that, and they're inside one of our schools. Say it's a school that's a rural area that's got 45 minutes before a law enforcement officer could even get there. If this person is jumping up and down and shaking their hands all over the place and just really causing a ruckus, which is going to create fear in our children if they're witnessing all this, and that principal and teacher's like, let's just get this guy outside, have him send an ambulance too, but let's get him out of here away from the children. That would be what the law would be designed to do. Because if I agree, law enforcement should be used whenever you can, but if they're not there, somebody's got to protect those children. In that case, where we're talking about a school. Does that answer your question, Representative?
Representative Provenza, follow up?
Kind of, I guess where I have concerns with that when you give the school example is teachers and staff at schools are trained to kind of put kids in separate rooms or remove them from that situation altogether to get away from the active threat. And so if their resources are now spent trying to push this person out, which maybe it goes the way you do, and I hope it does. My concern is when that person doesn't respond in that way and they become much more volatile and we don't have the resources on the ground to de-escalate with force. I mean, and it creates a much more dangerous situation. Are the people then liable?
Mr. Gray, does the disturbing individual have a vote in this situation?
Chairman Washington, I'm not sure I understand your question, sir. I apologize.
I think the question deals with the individual who doesn't respond well to coaxing them out the front door. Will that escalate? Because that individual has a decision to make, whether they're impaired or not. They have a decision to make whether they're going to cooperate with that principal or not cooperate with the principal in the 35 minutes in your example that you're waiting for law enforcement to get there.
Mr. Chairman, Representative Provenza, I hope I do better on answering it this time. I think we're looking at the reasonable standard at this point. What would be reasonable in this situation? A reasonable person in our society, a principal, for example, they're expected to exercise a degree of attention, knowledge, intelligence, and judgment that society expects of our members to protect theirs and others' interests. And that's just right out of Black's law. But a reasonable person, knows that water drowns, fire burns, a knife cuts, a gun shoots. We are held to a standard in our society, whether we're a law enforcement officer or not, to act reasonably in our decision to place hands on somebody, to remove them in a situation. Yes, when you do that, you just take on responsibility. Could somebody be sued for doing that? Absolutely. Absolutely. And if they used unreasonable force, force that was not proportional to the force being used against them, absolutely, they might file a claim with the district attorney's office, the county attorney's office, say, hey, this was too much force used against my client.
Other
Does that
questions?
answer? I'm sorry.
Representative Shostak.
Thank you, Mr. Chairman. Mr. Gray and also Representative Craigo. I am a little concerned about this bill only because I appreciate your statement that you don't want vigilante justice, and I totally agree with you on that. We don't want to encourage vigilantes at all. I fear that this creates a little bit of a increased possibility of vigilantism. So that's my hesitation on the bill. I'm not sure yet how I'm going to vote on it, but I'm a little concerned about it. But one of the things, and one of the ways in which this, I think, appropriately lowers the risk of that there's a lot of adjectives: reasonable, appropriate, reasonably. All those are good. I like those words. I think they're important. The question that I have, and this might be better addressed to Representative Craigo, is, and I don't know the common law about this. I'm not done the research, but is the reasonableness standard an objective standard or a subjective standard? In other words, does it matter? I think this is true, or a reasonable man would think this is true. The objective versus subjective standard. Which is it? It's not. It looks like it might be different for different parts of it. Reasonably is all through this thing, which is a good. I think that's a good word. But if it's an objective, reasonable standard, that I think does increase the risk of vigilantism, and that's so I need to understand how that word is being used.
Representative Craigo.
Mr. Chairman, Representative Chestick, I've always assumed that when I see the word reasonable, that it's an objective standard. For example, if we turn to page 2 of the bill and we're line 2, it says what the owner, occupant, or agent reasonably believes. Let's take that language. Let's just divide that out real quickly. If it was a subjective standard, we wouldn't use the word reasonably. We just use the word believes, and then that would create a subjective standard. As long as that person believed, whether it was reasonable or not, whether another person in their shoes would have felt that way, it's irrelevant. But we're saying it's the objective standard. What would a reasonable person in that position believe the facts to be?
Further questions? Representative Harrelson.
Thank you, Mr. Chairman. So kind of just let me give a little bit of a 30,000 for you. I pastor a church, and I have an individual that we've been working with for a number of years that has a drinking issue, and he's never mean in that realm, but he is disruptive. And this individual, we have a policy. We'd love you to have you at church. We want you at church, but if you're drinking, you're not allowed at church. And so like I can see in this situation, the reasonable aspect is, hey, I'm going to put an arm around you and I'll walk you out, and we'll have a conversation out front, and we'll try again next week. Under current statute, that I can't do that. Correct. And then secondly, under this statute, I could legally put that arm around him, and I'm not dragging him out. I'm just saying, hey, why don't we move this direction? And so is this that's how I'm viewing this. This is a deal where, and obviously in every situation, the force that this individual is trying, if they start fighting you, obviously things could change, but this is the opportunity to just say, hey, why don't we just exit stage left and talk about this outside, or whatever it looks like. That's what this does, correct?
Representative Craigo.
Thank you, Mr. Chairman, Representative Harrelson. As I stated a little bit ago, I think you can already do that. What this is doing is trying to put it in statute versus common law / case law. I believe you have the right to do that. I don't think any prosecutor in our state is going to bring charges against you, or will any civil suit stand up to those types of actions. All we're trying to do is make that information and what I believe the law to be more accessible to the general public. And that's the purpose of this statute change.
Further questions? Thank you very much. I do appreciate you driving all the way down to be here this morning, Mr. Gray, and stay close. Maybe we have a follow-up question or two for you.
Yes, sir.
Thank you. Anyone else in the room wishing to testify on House Bill 126? Mr. Winnie? State your name for the record and then tell us what you want us to know about House Bill 126.
Yes, sir, Mr. Chairman. Bill Winnie, Winney, Sublette County. Along the way of my 30 years of active duty in the Navy, I served as a Article 15 or non-judicial punishment hearing officer. Probably heard about 600 cases over those 5 years I was in those positions. Been on a court martial twice on serious charges. And excuse me. I look at the word here and you all have already struggled with what's reasonable. And I got it. And I find it alone too broad. I understand where they're trying to go, but I think it's too broad. Where do you cross over from an assault that is simply physical proximity without touching to an assault where touching is brought in? There are those in this world that are very artful at enticing an unsuspected person into some kind of behavior that they can then go after. And that's kind of what I think you all are struggling with when you talk about reasonables. What do you do when you got that kind of guy that's trespassing, but knows how to entice seemingly unacceptable behavior from the owner of the property? And that artfulness is important because that doesn't always come out in a court. I think you may want to consider when you say reasonable, consider an additional phrase in there to include physical removal or something like that to get into that concept of physical touching or whatever can be legitimate under this law or under this proposed statute. Subject to your questions. Thank you.
Question for Mr. Winnie. Thank you very much for being here this morning. Anyone else wishing to testify on House Bill 126? Anybody on Zoom land? Bring them in, please. Just Mr. Carpenter. Not on Zoom. So we lost our virtual witness. Anyone else? All right, I'm going to close public comment. Committee, what's your preference?
The bill.
Moved by Representative Provenza, second by Representative Nemec. Any amendments? Any amendments? Representative Oakley?
Thank you, Mr. Chair. Not an amendment, just for discussion, or is that fine?
All right, if there are no amendments, let's start with discussion. Representative Oakley.
Thank you, Mr. Chair. So I'm ambivalent about this because, as we discussed, the standard in common law is reasonable. So basically, in that way, this is redundant, and that's why I can be ambivalent instead of against. I will say this. I understand that a lot of people don't really know how the common law works, but basically what it would be if you were charged with something, then you would have the defense that it was reasonable force. So that's already there. And one of the things that happens when we start trying to write things like in the black letter of law is actually it can narrow the circumstances under which it's appropriate or it fits. I don't know that does that here because it just it says reasonable, which is what the common law would be anyway. But so yesterday there was a bill, House Bill 120 that tried to, that again, not understanding common law would have basically effectively kind of erased reasonable suspicion. I won't get into that, but I looked that up and there were over 5,000 cases that discuss reasonable suspicion in our case law. Like it becomes really developed, more sophisticated law that can deal with multiple situations. And when you start narrowing it, so we made a defense. It was the stand your ground law, self-defense law, and as a practitioner, what we've seen is that's become the go-to, and they've done trainings on it. It's become the go-to defense for domestic violence perpetrators, because I'm lawfully in my house and I don't have to retreat, and then we have to do hearings. So on the ground, it hasn't worked really well, and it hasn't worked. It's largely worked for an area of law that was not contemplated. So with all of that, codifying defenses is something that I'm a little bit leery of. But again, I can probably go with this because I think it just says what would exist in common law, but, and I don't think this is a really well-developed area of law that has a lot of cases that you're going to be taking it out of that realm. I don't know if this makes any sense, but I will say that basically this standard is already what you can do. You can already use reasonable force to remove somebody. I mean, it's reasonable, right? That's what it is. So I'm not a fan overall of taking something that already exists and then actually, like I say, trying to put it in the black letter of the law, which can be restrictive. So with that, that's just a little background that I'm not a huge fan of statutory reasonable defenses, but I don't think this goes too far.
Thank you, Representative. Any other comments from the committee? Representative Craigle.
Thank you, Mr. Chairman. It's kind of fun when Representative Oakley and I are maybe on different sides of an issue, because that doesn't happen very often. So this is fun. Section E, the reason we put that in there is really to address the concerns that Representative Oakley just expressed. We are not trying to change self-defense law. In fact, we make it very clear that this doesn't really apply to self-defense of self or another. And so that's why we put that in there. This is, very clearly in subsection E. That's the purpose set forth in there. And that's why we did that, is sort of to address that concern that Representative Oakley just brought up. So anyways, just was going to mention that, and hope we all get an aye vote on this.
Representative Provenza.
Thank you, Mr. Chairman. Putting this in statute to help landowners or anybody really to decide that I can then take somebody off my property. I don't know that putting it in the statutes is necessarily going to solve it. I think what we have is potentially an educational issue. And I think then there's the potential for it to complicate things. I try to envision what a juror might look at this as, and I think we've got reasonable in here at least 3 separate times, just in paragraph D, and then we've got what's justified, what's appropriate. We've got the word terminate. These are, while they might have objective standards, I'm just trying to envision a reasonable doubt is a doubt based upon reason, in addition to all the other pattern jury instructions that they're going to receive on this. And if common law is already doing this, and we've heard about prosecutorial discretion, if I don't have a ton of cases coming before us that are saying that prosecutors are not using what the common law is, that they are being extra punitive towards folks who are trying to do what this bill is intending to do, then I don't have a specific problem to point to other than an educational component. And so I think what we need to do is make this more accessible to the public, this understanding of what can be done, rather than potentially create what could be a mess, as we have seen with our stand your ground laws. So I'm a no on this for those reasons. But I appreciate the good bringer of the bill and the folks that came today to testify for that. So thank you.
Representative Justic.
Yes, thank you, Mr. Chairman. I'm also, I think, a no on the bill, although it's a soft no. I think it's not a terrible bill, but I worry about unintended consequences, and along the lines that Representative Oakley was saying, it's already covered by common law, and I do trust the courts to have common sense and do a case-by-case analysis and figure it out for each case, which is how the common law works. Codifying it ossifies it, it solidifies it, and that could be a problem. I also am concerned. The fact that I do agree that, especially on line 2, whether the occupant agent reasonably believes, that probably is an objective standard. I'm not so sure about the reasonably on line one. That might be subjective, but I actually prefer the subjective standards because the objective standards increases the possibility of vigilantism. So for those reasons, I'm also a no.
Question being called. We have a roll call vote on House Bill 126.
Representative Craigo,
Aye.
Representative Chestick,
No.
Representative Haroldson, Representative Jennings,
Representative Jennings left an absentee vote of aye.
Representative Nemec,
Aye.
Representative Oakley,
Aye.
Representative Provenza,
No.
Representative Rodriguez Williams.
Aye.
Chairman Washut.
Aye.
We have a total of 7 ayes and 2 noes.
Very good. 7 ayes, 2 noes, and Representative Craigo, you'll handle the bill on the floor.
Thank you. Yes, Mr. Chairman, I will do so.
Okay. Which brings us to the bill, which I think many of you are here for, House Bill 113, Representative Oakley. We still have a quorum, so you may proceed. Would you walk us through House Bill 113, please?
Thank you, Mr. Chairman, members of the Judiciary Committee. I bring to you House Bill 113, which is the repeal of a section, not something we do all that often. So it's subsection J of the DUI statute, which is 315233. And so what I'd like to do to start out with is point out the title here, which is judicial permission to dismiss DUIs. Because right there's the rub. So this is the judiciary giving the executive branch permission or really being involved in any way in prosecutorial discretion. So I assert to you that this is a significant separation of powers issue. Prosecutorial discretion is a touchstone part of the executive power in the criminal justice system. Prosecutors have to make decisions every day and do in relation to all sorts of things. Decisions are made whether there's enough evidence regarding cases from, shoplifting to rape to murder. And that is the power that's vested with the executive branch, period. And again, it's at the very heart of what a prosecutor does. So I've gotten some emails from, people who are either in law enforcement or strong supporters of law enforcement, which I certainly am, that say, have said DUIs are dangerous. Why would you want to make it lighter or easier on this dangerous crime? And the short answer is this does not do that. That's not at all the intent or what this would affect. It's that this is not about taking good DUI cases and dismissing them and not prosecuting them. It's so funny, the play that happens when we're looking at bills, so many are, those prosecutors just want to just hammer everybody for everything. And then you do this, something like this comes up and they're like, oh, wait, we've got to try to control the prosecutors, make sure they're doing their job. Quite honestly, probably, there is something to prosecutors wanting and believing in prosecuting crime. The idea that the judiciary would somehow be more heavy-handed, I don't think is correct, but more importantly, their decision is their job is to be the neutral arbiter, the judicial system. They're not supposed to be involved at this front end of cases, period. I was saying, I'll just throw this out there. I was like, maybe this is the trifecta of a separation of powers problem. Because here we sit as the legislature making laws that saying the executive branch has to go to the judiciary to get permission for their decision. And it's just, it's blurring lines, and it's always been an issue. So there are very few cases that might be appropriate for a deferral or a lesser charge that prosecutors would like to see. And so from that, I'll give a real world example. There was a man that was in a fight with his girlfriend, verbal. It wasn't a domestic violence situation. They'd been drinking a little bit, and he wanted to remove himself from the situation, winter in Wyoming. So he went out, got in his car, started it. I can't remember what, but an officer made contact with him, and that is an actual physical DUI, which is certainly there's a good tool in actual physical control DUIs. So it's not about changing that. There's all sorts of times where somebody may not have been seen driving or something, but they're passed out behind the wheel, and when they wake up, they could put it in drive. So not to belabor that, but there certainly is a good time for that. But it can be a gotcha a little bit, right? And with sort of a no tolerance policy on DUIs, the man got a DUI. He was a 0.09. And then, so on top of that, and this really exacerbates this problem to me, the man had a CDL. And we have federal law that prohibits people with CDLs, not when they're driving commercially, at any point. If you have a CDL, we are prohibited from allowing to give them a deferral. So here's the case where a man, we can go into this, arguably is doing the right thing, removing himself from a situation, right? There's just layers to this. Removing himself from a situation where he's fighting with his girlfriend, goes to a vehicle. There, as far as we know, there wasn't an intent or a plan to drive, a low BAC, and he has a CDL. So I'll just say it, he's a working man, and that's who we can't give a deferral to. So I can't, and then on top of that, but I can't go, what this does, then I'm supposed to go on my honor, on my duty, and swear that I can't uphold the case. Well, I can't do that because actual physical control DUIs are a thing, and it is illegal. So, I'm not going to put my ethics or myself on the line. So my hands are tied. So that man, in the lightest situation you could imagine, perhaps not a dangerous one, and that's the case that I can't do anything with. I promise you, we have DUIs very heavily in Fremont County. We just had a survey. We topped the list. It's certainly not an honor, if you will. We prosecute a lot of DUIs. Nothing about that would change. This certainly would not change that. So I guess just in finishing, I just discussed that I testified yesterday on House Bill 120, and I think perhaps that was a case again where the people bringing the bill don't understand the complexities or the depth or whatever you want to say about case law and how it develops and how the criminal justice system all works. So the opposition I've seen to this, in my estimation, also doesn't understand or give the grace to prosecutors to understand what prosecutorial discretion is, how it's used, that prosecutors are not just going to start dismissing DUIs. I don't think that's happening. If it is, then you need to change your office at your local level. But when you try to chain it in statute. It has unintended consequences. I think that's what it is here. And on top of that, I do not believe, I do not believe this is constitutional. I think there's a significant separation of powers here. So we can do the good work and something we don't do very often, and we can repeal law. So, so with that, I stand for questions.
Representative Oakley, do you know how long Section J has been in Wyoming statute?
Mr. Chairman, that's a good question. I have an idea in my mind, but then when you just asked it, I thought I'm not going to throw that out there because I don't know where. Let me look and see if it. Mr. Chairman, I do not know. I might have some either help online or in the room that could.
That's
Nope.
fine. We'll see if this is my address track. Any other questions for Representative Oakley? Representative Provenza?
Thank you, Chairman. How many laws in Title VI or in other criminal code have this provision in it where you have to justify not bringing a case?
Representative Oakley?
Mr. Chairman, Representative Provenza, thank you. That's a great question. And I really think, again, that's to the heart of this. Zero. And I don't think it would stand up if we had review of this. I don't believe that, but that's really key to understand. So there's this random, law hanging out attached to DUIs when prosecutors in your state have the discretion for every type of case, every decision made, domestic violence, rape, murder, shoplifting, name it. People, gathering evidence and figuring out where we're at with the statute. That's, like I say, it's the very heart of prosecutorial discretion in making those decisions. So it's really this outlier and again, that I don't think should exist in statute. Thank you.
Representative Provenza, follow up?
Somewhat separate. So in rules and procedures or with the bar, what oversight is there? So say a prosecutor just says, I'm just not going to go after DUI cases. Is there another mechanism in which we can deal with a prosecutor who's perhaps too lenient?
Representative Oakley?
Thank you, Mr. Chairman. Representative Provenza. That's an interesting question because it really, again, goes to what we're talking about here, which is there really isn't, but the whole point is that's writing things in statute is not how systems work. When a community, let's say, is unhappy with their elected official, because of course county attorneys and district attorneys are elected, our whole system is based on then they get unelected, and we have city councils and we have police force. City police force. You have this whole system that supports each other and works together. And sometimes, of course, that goes off track. I know that there is a county here in Wyoming that feels like it's gotten off track. And I'm like, it may not be an easy, perfect process, but the job of the community is to get that back on track. And it's a complex system with a lot of people involved, but that's the system that works. And I can say every time you think that you're just going to write a sentence or two down in the law and that is going to fix those problems, it doesn't have that effect. You have to get all of the pieces working again. I say it's like a three-legged stool. You need prosecutors to do their job, you need defense attorneys to do their job, and you need the judiciary to do their job, like in the criminal justice system. And when one weakens, you can see it in a variety of ways. But so the long answer for a statutory fix when the system starts getting off track, it doesn't have the effect that people want. I understand it, but that's just not how it works.
Further questions for Representative Oakley? Okay. Do you have any witnesses with you today or?
Thank you, Mr. Chair. So I know they're not like with me, but WTLA, I believe, wants to testify. And then I think Mr. Peterson is online and perhaps Mr. Stanberry. And if I may go a little further, the prosecutors I talked to, like for example, my boss is in, I think, a sex assault trial. I have prosecutors in favor of this too, but I'm not sure that I got any lined up. We'll see. But I certainly have prosecutors on board with this. And then I know some practicing defense attorneys as well. So I don't know who's online.
I do believe we have Mr. Peterson and Devon Peters, may it's female, I'm sorry, and Jeff Stanbury. So why don't we bring in Jeff Stanbury to start? Mr. Stanbury, can you hear us?
I can. Thank you very much. Can you hear me okay?
Yes, we can. Please state your name and position or who you represent and if anybody, and tell us what we need to know about House Bill 113.
Thank you, Mr. Chairman. Yes, my name is Jeff Stanbury. I'm a practicing criminal defense attorney in Fremont County with the firm of Stanbury and Strike. I've been practicing criminal defense for, I think, nearly 19 years. Obviously in the state of Wyoming, the DUI statute is one that we run into quite often. I have worked against Miss Oakley for several years now. But one common thread that we have had is trying to determine the appropriate justice for particular, and this really gets at the heart of the issues, specific DUI offenders. The outcome of our cases usually is geared towards how can we accomplish justice? How can we achieve a deterrent effect so that, from my perspective, that my client never commits a similar offense again, and from the state's perspective, to both ensure the protection of the community and deter both others from committing the crime and this specific defendant from committing the crime. I have never prosecuted in my career, but I have had a firsthand experience in witnessing the anguish that some of these prosecutors go through in terms of trying to determine what the appropriate outcome of a particular case is. And so my outside perspective as a voter, as a citizen, and as an attorney is that the goal of the prosecution really is to deter criminal behavior. And that goal is not necessarily equivalent with obtaining convictions. This statute, its goal is to obtain a conviction. It is not necessarily synonymous with deterring criminal behavior. And I think that the example that Representative Oakley gave is a perfect example of that. That is, how do we condition behavior so that we achieve the goal of the statute? And the goal of this statute, I think we all can agree, is to protect the community by removing drunk drivers from the road. I too have another example where this provision of this statute worked against that goal. Early on in my career, I had a couple guys who were out working in the oil field. They got in late. They hadn't eaten anything all day. And they went into a bar and they had dinner and they drank, in their opinion, a couple too many beers. And rather than drive home, they got in their truck and one slept in the front seat and one slept in the back seat. They determined that they represented a risk to the road and made the decision not to drive home. However, as Ms. Oakley has illustrated, this is an actual physical control DUI. This is one that they can obtain a conviction because the keys to the vehicle were in the ignition and it was available and readily to drive away. But they made a good decision. And when we came to trying to resolve that issue, the prosecutor was left with no choice but to pursue a conviction under the DUI statute. And the judge in that case had a policy that he wouldn't grant a 301 for anything over a 0.10 at that time. My client's comment to me, right or wrong, was, well, next time I'm driving home because I'm a sitting duck in a parking lot. Now, that's not the sort of comment that we, of course, want to hear, but it's a realistic comment. And when prosecutors and defense attorneys are dealing with trying to fashion behavior to protect the community, that's not the comment that you want, but you understand perhaps where this person is coming from. That person lost their employment from making a decision that he felt at the time was a better decision than getting on the road. I echo Ms. Oakley's sentiment, and this is the only law in the books that is the case. The prosecutors are charged with evaluating the facts and looking at the specific defendant and the conduct of that defendant and whether it rises to the level of full prosecution. And in this instance, we're essentially taking a defendant and equating that defendant who made a choice not to get on the road, and in Ms. Oakley's case, a defendant who made a choice not to get on the road, and equating that with a defendant who drives down the road with a 0.3 blood alcohol content, and handcuffing the prosecution from treating those instances differently based on that content and how they hope to fashion and deter conduct in the future. And so what I'd ask this body to do is evaluate those circumstances. We trust our prosecutors around the state to make these decisions based upon those factors and amend statutes or criminal charges that are much, I want to be clear, a DUI is a serious offense, but are punished much more severely than a DUI. I think it was Representative Provenza that asked the question, is there another mechanism for dealing with prosecutors who become too lenient on that? And I think Ms. Oakley did address that somewhat, but yes, there is. It is the ballot box. If our streets become populated with drunk drivers because our prosecutors have abused that discretion and not prosecuted people to where citizens are at peril, someone will step up and run for office. And that is our mechanism to change the exercise of that discretion.
Mr. Stanberry, thank you for your time. We're trying to limit the testimony to about 3 minutes. So I think you've offered some very valuable points, but thank you very much for joining us this morning.
Thank you very much for allowing me to speak, sir.
All right. I got a little ahead of myself. Are there any state agency people wishing to talk about House Bill 113? Okay.
Thank you, Mr. Chairman.
Good morning. Please identify yourselves for the record and then tell us what you want us to hear on House Bill 113.
Sure. Mr. Chairman, Taylor Rossetti, the Support Services Administrator at WYDOT. To my right, I have Misty Zimmerman, who is the Driver Services Program Manager, and Lieutenant Colonel Walther of the Wyoming Highway Patrol. We've heard today that DUI is definitely a serious offense, and it is an offense that occurs quite frequently in Wyoming. I believe last calendar year, there were around 5,500 convictions for DUI in the state of Wyoming. And there were an additional 200 or so charges that were either amended or dismissed. So that's a pretty high incidence of the infraction. I think the example that Representative Oakley brought up actually does help to start illustrating the one of the areas of concern that we do have, and it's that concept of when the offender happens to have a commercial driver's license. And in the physical control example that was given at a 0.09, I do believe that a dismissal in that case could get us into trouble with the Federal Motor Carrier Safety Administration as an incidence potentially of masking. Now, I do believe that within the knowledge base and the prosecutors in the state that are knowledgeable about this, they would probably be aware of that and understand that is probably not a great incidence where this dismissal may occur. But there's always the reassurance on our side that there's the second check in the judiciary in case it's a prosecutor that maybe missed that as they were going through. Additionally, I do think that we mentioned the 301 deferral in Mr. Stanberry's comment, and even within that deferral statute, there is a specific stipulation that does mention if the person happens to hold a CDL that doesn't apply. So there is that backstop on the deferral side. We do feel like this second check in the judiciary, while maybe being a separation of powers issue, does serve us well to have that second check to ensure that one of these CDL holders maybe doesn't get through unintentionally. With that, Mr. Chairman, I'd certainly have these folks available to answer some questions.
Please join in.
Thank you, Mr. Chairman. I currently don't have anything to add with this. At this point, I think Mr. Rossetti's addressed what we had to say.
Measure.
Mr. Chairman, thank you. Josh Walther, Lieutenant Colonel with the Wyoming Highway Patrol. I think Representative Oakley did a great job of diffusing a lot of the concerns that I think we have in law enforcement. And I trust her judgment with prosecuting cases and doing the right thing. I would still just state, though, that the concern here, and Representative Provenza asked a great question, which to me was about oversight, additional oversight. And does it still exist? And I get the comment of the ballot box as the additional oversight, but to me, that's not oversight per case. That's oversight per several cases when a term is up and you determine if somebody's going to be voted in again or not. So you still have the potential to lose a significant amount of cases in that meantime, depending on how much more time they have in office or elected in that term. So that still is a concern for me. Maybe not so much what Representative Oakley would do, but obviously there's numerous prosecutors around the state. And does this provide unintended consequences or unintended issues with other prosecutors potentially dropping cases without that additional oversight? Does that still exist? And that could just be ignorance on our part and not understanding the entire process, but that's our concern.
Thank you. Questions for the YDOT team? Okay, I have just one. Are you aware of how many times a judge has refused to allow a prosecutor to dismiss a case where they come in under this section J, stated their case, and the judge said no?
Mr. Chairman, I'm not aware of that number.
Thank you very much. Other witnesses in the room? House Bill 113, anyone? Ms. Lance?
Morning,
minutes.
Mr. Chairman, members of the committee. My name is Beth Lance. I'm here this morning on behalf of the Wyoming Trial Lawyers Association. Our association supports this bill. Just a couple of points that I'd like to address to the discussion that you all have been having on this bill. First, when we have a prosecutor who is potentially seen as not maybe bringing charge, handling cases the way we'd like them to. Obviously, we've mentioned ballot box being the solution, but I would just like to say in practicality, when we've seen prosecutors that maybe are not doing what we want them to do as citizens, typically they're not bringing cases at all. So this bill would not affect or help those prosecutors along, because unfortunately, what those prosecutors are doing is simply not bringing charges. They are deciding for whatever reason to bring less cases or not prosecute certain things. And so when that occurs, this bill doesn't help that. This bill is where a prosecutor has had a case brought to them by law enforcement. They their initial take on it is, yes, I'm going to file charges. What happens is then upon getting a lot more information through the process of discovery and going through the case with law enforcement, they realize that there may be other things in this case that lead them to feel that the just outcome is a dismissal. And so, again, the charges were brought. The prosecutor is doing their job. The prosecutor is bringing the charges. This is just an instance where, upon getting a lot more information later, the prosecutor is reassessing whether that case should or shouldn't go forward. I would just say too, as we heard some statistics, obviously dismissals are fairly rare in and of themselves. And I will say, as a having practiced criminal defense myself, dismissals really only come when I can show a real defense. So as a criminal defense attorney, when I'm going to the prosecutor and I'm explaining that I think I really truly will be able to prove my client innocent because there is a defense existing in the case, it's really typically the only time a prosecutor is going to agree to dismiss a case. What we're talking about here is a very, very small minority of cases. We've heard a couple anecdotal instances where people can recall these very specific instances where a prosecutor maybe could technically prove the case, but it would not actually be a just outcome to necessarily move forward on prosecuting that case. And the question then is, with this statute, the way it exists is that prosecutor has to go in front of the court and they basically have to swear that they can't prove it. Well, we can't, if it's an instance where technically the prosecutor believes that they would be able to prove it, but it isn't what the just outcome is, then their hands are tied, as Representative Oakley explained. And then they have no options available to ensure what is actually the just outcome in that case. Again, just saying that I think this affects a very, very small amount of cases. I think overall DUI cases are prosecuted. They're prosecuted correctly in this state. Convictions happen far, far more often than dismissals because typically the facts are there and the case is there. Law enforcement's done a good job, et cetera. And so, but in the small amount of cases, I do see this as very questionable legally, because prosecutors should have the ultimate discretion, and the judiciary should just be deciding sentencing and things that are appropriate for them to determine.
Questions for Ms. Lance? Seeing none, thank you very much for your testimony. Devon Peterson on Zoom. Good morning. State your name and who you represent, and you have about 3 minutes to tell us what we need to know.
Thank you. Good morning, Mr. Chair. My name is Devin Peterson. I'm a Wyoming lawyer with the firm of Fleener Peterson. We have our offices in Laramie. I don't have a ton to add. I think a lot of it's already been said, so I can certainly keep it within 3 minutes. I support this bill. As the others have said, this is unique in our entire statutory code. As Representative Oakley said, I cannot think of one other statute that's like this. I tried to do some research while everyone was talking to see when this was passed. I'm not sure, but I'm sure it was sort of in a moment of fervor against DUIs. But, you know, as serious as DUIs are, as Representative Oakley said, we have, you know, murders, rapes, all kinds of very serious charges where prosecutors do not have to go in front of the court and explain why they're doing what they're doing. And, you know, I think this has come up in other areas over the last couple of years about prosecutors and prosecutorial discretion and in our system. And, you know, judges call balls and strikes, right? If two parties disagree, the judge decides what to do. And I've always thought about this throughout my entire career. I used to work for Judge Young, who Representative Oakley knows. He's now a retired district court judge. And you know, he would refer to himself as a pop machine, and he doesn't do anything until a quarter's put in him. And I never really understood what that meant until more later in my career. And the way I think of that now is these cases, criminal cases, are the prosecutor's cases. They're not the judge's cases. The prosecutor brings the case to the court. And in this statute, it has that backwards, where the prosecutor is going to the court and saying, Your Honor, is it okay if I don't bring this charge? That's not the judge's role. The prosecutor just brings the case. The defense attorney defends against the case. And when they have arguments and the judge needs to weigh in, the judge weighs in. So I just think this is a unique, I'm not sure how it, got through again in the first place. I'm sure it was in a moment of, maybe some bad DUIs or something like that. But as bad as DUIs are, this just isn't an appropriate way to respond to that. And it should be repealed. And I stand for any questions, Mr. Chair.
Thank you, Mr. Peterson. Any questions, Mr. Peterson? Thank you for joining us and giving us your insight this morning. Do appreciate that.
Thank you, Mr. Chair.
I'd just like the YDOT folks to come back up. I have a quick question for you. There was a comment made about putting that if a prosecutor were to defer a case with a .09 or something, that we might get in a difficult position with the federal folks. Can you elaborate a little bit more about what are our obligations as a state? And if one prosecutor were to overlook the fact that an individual had a CDL or get sideways on CDL regulations, how would that affect the state?
Mr. Chairman, I'll take a stab and then Ms. Zimmerman may have to clean that up for me, but there is a provision within the federal law, and commercial driver's licenses are really governed at that federal level. Our personal licenses are not, but the commercial driving privileges are. And one of the requirements of us to have a certified program, which means that our commercial driver's licenses can be issued and are recognized around the country, is that we have certain laws on the books to make sure that we abide by those requirements. The instance of a single prosecutor doing something is probably not where it becomes alarming. It's where if it were to become a pattern, that I think this happens. But they do a check when they look at our program and ensure that our laws are in substantial compliance with the requirement of the federal law. And this one is really, I think, kind of on the edge of that. I think on its face, it probably doesn't violate the tenets of that. But I do think in practice, if it were to become systemic that a bunch of these were getting thrown out, I think it could lead down the road to some findings for that. And some of the things that are in there is that we shall have in effect and enforce a law providing that an individual with a blood concentration level at or above the level established within federal code when operating a commercial motor vehicle. So that's another key thing, right? There's a difference between them operating the commercial vehicle and the personal vehicle. So you have to have that much knowledge. And we do have that statute in place. That's 317305. So we have a statute that conforms there. The example we discussed here, though, is a little bit more unique in that it takes you out of that person wasn't in a commercial motor vehicle. They were in their personal vehicle, but held a CDL. And at .09, they'd be over the legal threshold for a DUI as was stated. That is also a requirement to be a DUI underneath the commercial driver's thing, which leads to penalties on the commercial driver. If those were to become a systemic thing that were being dismissed, which I'm not trying to say they would be, it could lead to a problem. The first step is generally a clawback of some money is usually the first step that they would do. And then the ultimate penalty that could be really detrimental and could hurt industry in Wyoming is they could decertify the program, which means we couldn't issue CDLs. Again, I think as proposed and explained by the representative, I'm not sure on a surface that this rises to the issue where it would lead directly to masking. But I do think it would require us to do some additional due diligence to watch whether dismissals raise the circumstances under which those dismissals might rise. And it could ultimately lead to some accusations of masking from the federal government.
Thank you. So section J that we're talking about repealing this morning, it is not per se required under these federal regulations to, as part of our compliance with the federal code?
Mr. Chairman, I believe that is a fair statement.
Thank you very much for, as I pondered that, I think I have a little more that I want to learn about that. We have Linda Devine online. Good morning, Ms. Devine. Welcome to House Judiciary. You have about 3 minutes to tell us what we need to know about House Bill 113 and tell us who you are, please.
Thank you, Mr. Chair. My name is Linda Devine. I'm a criminal defense attorney in Laramie, Wyoming. I'm a sole practitioner with Divine Law. I am actually just testifying this morning in support of this bill. I would echo probably what a couple of people said, that it's not very often that a defense attorney agrees with bills that a prosecutor may be bringing. I think in this case it is appropriate, and I actually applaud and appreciate Representative Oakley in bringing forth this bill. I'll just give you a couple of examples where I think a prosecutor would be inclined to dismiss a charge, but they were unable to do it because of the law requiring consent of the judiciary. One is similar to what I believe Representative Oakley brought forth. And in this particular case, an individual had left a bar here in Laramie, was waiting on a ride from a sibling. He had made the call. He was sitting inside of his vehicle. The keys were in there, but the car wasn't even running. He was just in there waiting on his ride. The prosecutor in this case could not dismiss that charge because she would not be able to swear to the judge that she could not prove the DUI. And that's what's required right now on these dismissals of a DUI, is a prosecutor telling the judge they could not prove it. I think going back to just systems, there are times when folks are just sitting in their vehicle waiting for a ride, no intent to drive. We give prosecutorial discretion on all other crimes out there, so I'm not really sure why this one would be any different. And with regard to the federal and the CDL, I will say this, in my experience, prosecutors are very tough on CDL holders, and rightfully so, who have been charged with a DUI. I do not see the masking, which is under the federal rules. They're stating that someone with a CDL will get a deferral or a dismissal to keep the DUI off the record. I don't know of any prosecutor that wants someone that holds a CDL to be able to still be out there driving impaired. So I think I am below the 3 minutes, hopefully, but I just urge the committee to vote yay, whatever y'all say, on this vote. And I thank you again, Representative Oakley, for bringing forth this bill.
Thank you, Ms. Devine. Any questions for Ms. Devine? Thank you for joining us and adding your insight. Appreciate that this morning. Anybody else in the room wishing to testify on this bill? Okay, nobody else on Zoom. We're going to close public comment. Committee, what's your preference? Move the bill by Representative Provenza, second by Representative Crago. Any amendments? Any proposed amendments? Amendment on the repeal, that ought to be, challenge. Discussion on the bill. Representative Oakley.
Thank you, Mr. Chair. So I have several things to address from some testimony. So I'll start with the federal masking. It is not federal masking to amend a charge. And it's an interesting concept because, of course, in a way, then we're also getting into the same realm, which is the feds telling us, what we're going to do. But so I do not believe that this is a problem with, you mentioned compliance with federal code. I disagree that it is. There's a per se suspension that happens. So if somebody has a 0.1 BAC that's reported, to the DOT. And so that happens anyway. So there's a per se suspension just for being on the road and having a BAC. So that handles that way, because driver's license is different than the prosecution of the crime. And then also to use that I think is inappropriate, because then it makes it over application of the law of a bad separation of powers law based on a small class. So CDL holders versus non-CDL holders. I think we're going down. I personally don't believe that the federal masking is relevant to this. But again, then we go back to the whole idea, the second step, using some language from the YDOT team. So there should be this is a quote, and it's good discussion, but there should be a second check in the judiciary. That's literally why we're here. That does not exist. That is not correct. The judiciary is not the second prosecutorial check. It's inappropriate. And there was also discussion, there's not oversight per case. Again, if there needs to be oversight, your oversight is done by your boss. It's done by your office. It's done by your community. It is not done by the judiciary. And so the idea of oversight per case from the judiciary on the executive branch just highlights that what we're looking at. It's not the system, and it's an inappropriate way to do that. The judiciary cannot be the oversight or the boss of the executive branch. So we get it. I think we're there. I think we've explained it, the problems with it. It's bad law and it's bad in practice. I'd ask for your aye vote.
Representative Provenza.
Thank you, Mr. Chairman. The United States Supreme Court has said that the purpose of a prosecutor is to seek justice and not to deliver prosecution or wins. And so I think that Representative Oakley made an important point that this might not even stand up if it had been challenged. So I would ask the committee to support this bill. So thank you.
Any further comment? I couldn't help but notice how many of the examples that were given dealt with actual physical control cases, as opposed to folks who are apprehended driving down the highway. And that might be an area of the DUI law that committee might want to take another look at. Seems like that is the one that causes prosecutors some pause and what is justice in those cases, where we don't really have driving. We just have somebody in the car with the ignition on, keeping warm on a cold winter's night. So anyway, couldn't help it but notice that one. So, all right, committee, do we have a question? Call for the question. Questions called. Roll call, please, on House Bill 113.
Representative Cragel.
Aye.
Representative Chestick.
Aye.
Representative Haroldson. Representative Jennings. Representative Nemec.
Aye.
Representative Oakley.
Aye.
Representative Provenza.
Yay. Aye.
Representative Rodriguez Williams.
Aye.
And Chairman Washit.
Aye.
We have 8 ayes and 1 no.
So with that, House Bill 113 is passed committee of the whole. Representative Oakley, you'll be carrying that on the floor.
Yes, thank you, Mr. Chair.
And that brings us now to a really fine piece of legislation, House Bill 145. Brought to you by your chairman. Is there anyone in the room going to testify on House Bill 145? Okay. Will you run the meeting while I?
Representative Washit, we're moving on to House Bill 145. If you can introduce your bill to the committee.
Thank you, Madam Vice Chair. Appreciate the opportunity. House Bill 145 is a bill that I've developed at the request of the executive branch, dealing with a provision in law that limits who within state government can have access to certain types of law enforcement sensitive information. And in some of our cases, the Department of Homeland Security has need to access some of that information, and presently they are not identified in statute as having that access. So I don't have a huge background in this particular area, and I'm sure the witnesses will be able to provide a better overview of why this change is necessary. The bill itself, fairly simple and straightforward. If you look on page 2, line 3, we're simply including the Office of Homeland Security for the purposes provided in statute. And that's the crux of the bill. We're simply adding Homeland Security. I think when we're looking at some of these circumstances of whether we're talking about terrorism or any other type of topic where it's deemed that we need to share information among stakeholder groups, it's vitally important that all the key stakeholders be at the table and be able to access that information. When we exclude a group that, if you look at the mission of Homeland Security, they're involved in some of these situations, but we haven't made that adjustment in statute to make sure that they have the lawful access to that same information as the other. So with that, Madam Co-Chair, I would ask that the witnesses at the table illuminate the topic a little more.
Thank you, Representative Washit. Please state your name for the record and.
Good morning, Mr. Chairman and committee. Appreciate the opportunity to be here today. I'm Lynn Budd. I'm the Director of the Office of Homeland Security for the state, and I have with me also Deputy Director Niken, George Niken, for other comment if needed. Anyway, just really quickly, because I think there's a lot of just maybe some information I need to share with you with the creation of the Office of Homeland Security and our responsibility. With the creation of the Office of Homeland Security, it was created for the possibility of the occurrence of disasters. That's natural events, as well as enemy attacks, sabotage, terrorism, civil disorder, or other hostile actions. Our office actually has 2 charges, and that is, as you can see, between natural disasters and other situations, we do Homeland Security work, but also emergency management work, which combines that mission in our office. Our role is collaborative, and we need to partner with diverse but related disciplines with an interest in the state's security. The definition of Homeland Security in the statute talks about the preparation for and carrying out of all emergency functions essential to the recovery and restoration of economy by supply and resupply, and goes on to address necessary actions to deal with disasters caused by enemy attacks, sabotage, terrorism, civil disorder, and other action, as well as natural events. It's very important for us to be able to have all of the information that we need in order to carry out those responsibilities. We need to work with private industry, including 16 different sectors of critical infrastructure, to help ensure that our communities have the lifelines and the services that they need. In order to do that, we need to evaluate whether or not there's a threat to those particular industries. One of the things that we need to think about is, as an example here, why we would need access to law enforcement information and why that would be applicable. Let's say that there is a situation where there is a group of folks tampering with gas lines or making a threat to electrical infrastructure, which we have seen a lot here in recent history. If that's an ongoing case, law enforcement cannot share that information with me at this point in time, which leaves me without all of the information to be able to inform not only the governor on actions as his Homeland Security advisor, but also to work with private industry, other communities, local jurisdictions, to ensure that they have all the information they need to be prepared for any type of situation that might threaten them. Coordination is an interesting word. It's the organization of the different elements of a complex body or activity so as to enable them to work together effectively. That's exactly what we're talking about, is being able to work together with all stakeholders involved, have all of the information that might be at hand for us to be able to make good decisions on how we can support our communities. And with that, I stand for questions.
Okay, committee, do we have any questions of Representative Washit or his guests? Representative Oakley.
Thank you, Madam Chair. So is this you're trying to get access to NCIC? Is that what this is?
No, ma'am. Mr. Chairman, Representative Oakley, we are not trying to get direct access to law enforcement information. We're just trying to actually protect law enforcement and give them the ability to share information with us as they deem appropriate for our mission. And I might explain further that a lot of this is related to the Fusion Center function. You've probably heard the words Fusion Center. Wyoming is the last state to get a Fusion Center, which basically is just a function created after 9/11, where it was determined that a lot of the things that happened with 9/11 could possibly have been deterred had agencies shared information. So the idea is that you get all of the law enforcement officials, state, local, federal, which we coordinate with all of those folks, as well as offices like ours, together to share information to ensure that we're all on the same page and we're able to share what little piece of information we may have or somebody else may have that will be the pieces of the puzzle that creates the actual picture of what's going on.
Follow up? Okay, Representative Haroldson.
Thank you, Madam Chairman. So if Homeland Security were to request information that law enforcement did not intend to give or did not think of giving, what I don't want to see happen inadvertently is an opportunity where down the road, different people, and we have an individual that's wanting to delve into areas that maybe they shouldn't delve into. Would this open the door for that to be a reality?
Ms. Budd.
Mr. Chairman or Madam Chairman and Representative Haroldson, I don't believe so. It is their responsibility to guard the information that they don't feel like we have a need to know. This just would allow them to share information that they do feel like we have a need to know.
Representative Washington.
Thank you, Madam Co-Chair. I think many of us in the room are old enough to remember 9/11 and the accusations in the aftermath that key groups in law enforcement, national security failed to connect the dots. You know, that, and I always suggest that that's kind of like looking at the night sky and trying to see a constellation that you're unfamiliar with, right? You just look up there and they go, well, it looks like a W. Well, there's a million stars that might form a W if you drew the lines between them. And so the role of law enforcement and Homeland Security in these situations is to connect those dots and to figure out which dots are relevant. But it is law enforcement's role to determine who we share that with, who needs to be informed. What we're trying to fix here is a situation where law enforcement makes the conclusion that Homeland Security needs to be in that loop, but they can't lawfully access that information at the present time without this statute change. Thank you, Madam Co-Chair.
Additional questions? Representative Oakley.
Go ahead.
Representative Craigo.
Thank you, Madam Chairwoman. Ms. Budd, so as I'm reading the statute, I understand your testimony that this is really about you requesting information and that it's about sharing, but I'm not sure that's exactly what the statutory language does. I mean, the way I read it, it provides direct access to the department, which I'm not necessarily opposed to. I mean, that doesn't bother me. I just know when we get to the floor and we have to explain this bill, I mean, I need to be able to explain to the other members, all of us need to, what our intent is. And that intent may not match the language we're trying to put in the statute. And I'm not, I guess I didn't appreciate your comment or response to that.
Ms. Budd.
Madam Chair, Representative Craigo, I will sort of correct the intent from our office. It's not about us asking for information. It's about allowing law enforcement to share information with us as they deem appropriate. So I don't feel like we need access to NCIC or those other tools that law enforcement uses, but I do want to have them have protection from liability so that they can feel comfortable to share appropriate information with us as they deem worthy.
Representative Oakley.
Thank you, Madam Chair. And thank you. So I think we're at the same, I think Representative Crago and I are at the same place, which is we absolutely are on board to get this done. You know, to share the information, but just making sure that the bill here isn't going that step too far and opening record access up in a way that you may not even want, to be honest. Again, that's why I said, like, I know how restricted like NCICs are. I'm trying to look at, and I should have done more, like, you know, looking at subsection C, access to criminal identification and intelligence information. But then it's adding your agency to that access that like law enforcement has. So the point is this, I need to look a little more, maybe you can explain it. If not, just to make sure that we put it in the right place, absolutely behind what you're doing.
Representative Washington.
Madam Co-Chair, I just call your attention to line 1, where we identify the State Board of Parole. Okay. The State Board of Parole does not have an NCIC terminal. They're not having direct access to any of this information. And so putting Homeland Security in that same litany of authorized agencies to access, they're going to function much like the Board of Parole does, where when law enforcement sensitive information needs to be shared with the Board of Parole, they have the legal authority to receive that. And that's what we're doing here, is we're putting Homeland Security in that list, just like the Board of Parole, to receive that information when it is disseminated and available.
Representative Crago.
Thank you, Madam Chairwoman. Mr. Chair. So I guess I don't disagree that that's the intent and the purpose. I'm just not sure. I think we're going to have questions when we get to the floor that the authority we're granting is much broader than that. And maybe I'm wrong, and you would know better than I, for sure, based on your prior occupation. I just know the debate that's going to come on the floor regarding this, which we all support the purpose of the legislation, that I'm just trying to curtail that so that when we get there, we have an explanation for why it's going here and why it says what we say it says versus what it may actually say, on what the words say versus what they're intended to say. If that makes sense, Mr. Chairman.
Madam Chair, Representative Crago, it does.
Representative Washington.
Thank you. It does. And I apologize for not waiting. But if we're going to have an objection with inserting Homeland Security on line 3, are we going to have a push on the floor to extract Department or the Board of Parole on line 1? Yeah, we're not granting Homeland Security anything that we haven't already granted to the Board of Parole. So if I'm certainly open to amendments, if a little wordsmithing might be in order to try and make sure we're not opening ourselves up to undue concerns on the floor, happy to consider any amendments. But you know, from my view, when I read the bill draft, we're not giving Homeland Security anything that we haven't given to the Board of Parole. And so if we don't have a real gut clenching worry about having Board of Parole access this information, probably ought not have any concerns about Homeland Security being listed in that same paragraph.
Representative Oakley.
Thank you, Madam Chair. I'm looking at lines 9 and 10 and wondering if maybe this is a way to address the rules and procedures may be varied between agencies. depending on the division's determination of the agency's use of the criminal identification and intelligence information. So I'm wondering if that is how there's sideboards put on how different agencies use the information. That would answer our question.
Ms. Budd.
Madam Chair, I will let you all discuss that, but I would just point out that within the language being inserted, it says for the purpose provided in 1913-105. So it's not, it restricts the purpose of us receiving that information to applicable functions of our agency, not for any other reason.
Representative Washington.
Madam Co-Chair, and as I understand this section, we are referring to rules and procedures established by the division that manages the criminal files, which would be our state agency under the Attorney General's office. So they're the ones who are going to set the limitations on what does and doesn't get disseminated to the Board of Parole, what does and doesn't get disseminated to Homeland Security. But again, if any on the committee have suggestions for how we might tighten up the language, I believe I certainly am, and I believe the executive branch is as well open to wordsmithing.
Additional questions? Okay. Doesn't look like we have anybody else in the room, but we do have somebody online. Erica Legarski, you can go ahead and let her in.
Hello,
Thank you for being here, Ms. Legarski. Go ahead and repeat your name and your testimony.
Madam Chairman, Mr. Chairman, thank you for letting me be remote today. I have a family member who's having a little procedure today, so apologies for not being there. Really appreciate the discussion here. Also really appreciate the bringers of this bill on behalf of us. So Erica Legarski, I'm a senior policy advisor for the governor's office. I work very closely with Homeland Security and also DCI. And in some of those conversations, I think as Director Budd alluded to, it's just one of those things that, you know, with the security clearance that they have, trying to share information, give some briefings to the governor. We just had found that within this statute, there were certain things that maybe they were not able to provide, that if they had had that authority that maybe we could have. And so just trying to clean that up a little bit. Really appreciate the testimony today and the conversation. And as Chairman alluded to, we would be very happy to work with you on any amendments or any additional conversation that you guys would like to have regarding this bill. Thank you.
Thank you, Ms. Legarski. Any questions of Ms. Legarski? Representative?
Thank you, Madam Vice Chair. I guess one question to kind of help clarify if this is the right place to be in trying to access records. Was there discussion with the state ombudsman in terms of where specifically the hangup was in being able to provide the information necessary?
Ms. Legarski.
Madam Chairman, we did not have that conversation, but that is definitely a conversation that we could have if you guys would direct us to do that, that we would be fine to do that.
Okay, seeing no additional questions, Ms. Legarski, thank you for your testimony.
Again, thank you very much.
Okay. Committee, what is your pleasure?
The bill.
Oh, closing public comment. Seeing no further public comment. The bill's been moved. Moved by Representative Crago, seconded by Representative Oakley. Discussion amendments. Representative Crago.
Madam Chairman, I don't have any amendments. I think I'm not going to speak for Representative Oakley, but I just was asking those questions so that we are all prepared. I have no problem with the language, the way the bill is written. I just am anticipating what all the questions are going to be when we get to the floor. And so I just want to make that clear that I think this is a good idea, something we need to do. That's the only reason I brought up the questions, is so that I'm prepared when we get to the floor to answer those questions that the body may have. And I'll be an aye vote.
Representative Washit.
Thank you, Madam Chair. I would just ask, the governor's office and Homeland Security and Attorney General to also anticipate what questions may come up on the floor. And if you can feed us information that might make us more effective on the floor when we don't have your expertise sitting next to us, that would be helpful.
Okay, question being called. Roll call vote for House Bill 145.
Representative Craigo,
Aye.
Representative Chestick,
Aye.
Representative Haroldson, Representative Jennings, Representative Nemec,
Aye.
Representative Oakley, Representative Provenza,
Aye.
Representative Rodriguez Williams.
Aye.
Chairman Washit.
Aye.
We have 7 ayes and 2 noes.
With that, House Bill 145 passes. Seeing no further business,